It's all yours, Ryan.
Awesome. Thank you everybody for joining us, and thank you for HTDC hosting. Cohort 5, correct? You guys can nod. I mean, I won't call on you. I'm not that kind of professor. I don't mind the Socratic method that we are taught in law school, but I don't do that to my webinar or seminar attendees. But anyway, I'm Ryan K. Hugh. I am an attorney with Hugh and Bordenave, my own small little law firm that I started with a personal injury attorney. I can get into it why a business attorney is partnered with a personal injury attorney. If you want to hear war stories, and we can talk story about that. This presentation is rather meaty, and as I said, it is kind of boring. Privacy policy and internet law isn't the most of sexiest or interesting types of law. Everybody wants to hear more about Johnny Depp and Amber Heard's defamation trial than they want to talk about online policy. I get it. So as this is a smaller group, which is perfect, this is like the size. I love smaller seminars with about 10 people because it allows us to dialogue. And as a local boy, I like to talk story more than, I was like, let me read from my wall of text of slides, because like I said, that will put us all to sleep before lunch. So feel free to ask questions. In this small group, just go ahead and interrupt me, because I don't, in the past, we've had people use the chat feature or they raise the hand. I don't see that, even though I have these giant double screens on my office. I still don't see that because, you know, it's about real estate space on your screen. So in this small group, just go ahead and ask, and either I will address it or we can talk offline, or however, you know, depending on the question.
If I see anything show up in chat, I'll chime in for you.
Perfect. On that note, don't ask me specific questions for your businesses or personal matters. This isn't that type of session. This is purely educational. So of course, as an attorney, you know what I just realized? I haven't shared my screen. Huh. No wonder you guys are looking at, by the way, if something does not make sense about that point, I was like, go ahead and tell me things are not making sense. I was mentioning earlier, I like doing in-person webinars because, in-person seminars, because it allows me to read people's faces. Does everybody see the disclaimer screen? Is that showing up? Okay, cool, thank you. Anyway, this was the title screen, so not anything you missed, but going back to what I said about disclaimers, yeah, this is just all basic general legal information. And for those of you who are interested in this topic, you'll probably find that a lot of the online privacy laws probably actually don't apply to you. You're exempt. But I would take everything kind of with a grain of salt, but also if you have specific compliance issues or questions, that's when you kind of generate a consultation with your direct attorney or counsel or advice, or might be a compliance person on the IT side. So why are we here today? Why am I a talking head on your screen? And why are we all, for those of us who have lovely backgrounds, wishing we were at the beach, or I wish I was hiking? We're going to talk about online data privacy. So I'm going to start in the first major block, big picture, giant kind of like overview map. The second kind of component is looking at specific types of regulation. And that mainly comes in the form of California's law, which is the CCPA, and the Europeans' GDPR. I think for this cohort and this group, and you guys can correct me wrong if I'm wrong, but generally, again, you're going to probably be exempt from both those large pieces of legislation. But I feel it's important to talk about them, because what happens when large markets or large countries or states set the regulation, everybody else begins to slowly follow. They might change or kind of, so by learning about this now, I'd say you're ahead of the curve. So that's kind of why it's important to kind of roadmap and see what's coming. And on that note, Section 3 is about thinking about your own privacy policy and things that you want to consider. I believe part of the packet of documents that you will get is a sample privacy policy. I'm just letting you know right now that privacy policy anticipates a large company that needs to comply with GDPR and CCPA. Why have I done that? It's just to show you the biggest kind of subset of the universe is that this is what it looks like for a large company. You would begin peeling that back for your own purposes about kind of tailoring your own privacy policy, given if you are exempt from those two pieces of legislation. Fourth component is working with third parties. So what I mean by that is insurance, your IT, or if you outsource your IT, of being able to articulate with them and kind of being cognizant is it's not just you on the small business owner or small business to take on the whole compliance bag of privacy policy and complying with privacy laws, but you really should be sourcing from others, not just attorneys in your quest to be more compliant or dealing with people's online privacy. And then hopefully if we have time, we will get to questions and answers. But as I said, please go ahead and ask questions while we go along. Does that sound good for everybody? Cool. Okay. Data privacy regulation in general, the current outlook is that we have very large economic blocks like the European Union through governance, or large states like California, and you'll see that I'll mention Colorado, Virginia, and Utah now, have privacy laws. And really the way the laws are really designed is they're basically in response to the way that Google, Facebook, Amazon, and a lot of these large tech companies have treated privacy and people's data and information is that they, for a long time, they have done as they please or done whatever they want with people's data. And on top of that, in particular, it is consumers. It isn't business to business relationships. It isn't certain kind of what I call kind of professional relationships. Maybe you have a medical website provider platform or something like that. This has a lot to do with search engines, social media, or as I said, like Amazon and your purchasing behavior and tracking that information. And so that was the response to that. If you remember a couple summers ago before the pandemic, we all got spam mail from every major retailer is like, we're updating our privacy policy, blah, 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 blah. And then you click delete, 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 or delete all, right? That was in large response to CCPA and GDPR. They sent that out as notices. In terms of the scope and the purpose of these regulations, a lot of times it is mainly to protect a consumer's privacy. That is things that we're already used to some extent by HIPAA or financial privacy information and kind of protection. Data privacy is aimed to protect your data that you give to them, that you have some type of privacy interest. So that's one component of the law. The other components of the law generally give investigatory powers to a specific government agency, or in California, the Attorney General's office, to, hey, this company has breached my data privacy. They have sold my data to somebody else that I did not authorize, or there was a hack and their data privacy was breached and the company didn't disclose that to me. My credit card information was stolen by hackers. So the government will be tasked to investigate violations of these laws. So those are the two major, is to protect your data privacy, but then also kind of give government the power to regulate the companies that violate it. So why is compliance kind of critical? Again, for large companies, the fines can be actually very hefty. And there's also oversight through annual audits and reports. A lot of times these fines can be percentages or per violation. So if you have a data hack that hacks like 1 million customers, such as if you're a giant hotel or airlines and you fail to comply, the fine is thousands of dollars per instance. So that is each individual customer or consumer that has had their data violated. So the fines can add up very quickly. So for smaller and medium-sized companies that do find themselves having to comply with these laws, it's one thing if one or two people's data has been hacked or stolen, or you haven't complied in respecting their privacy. It's another thing if it's 100, 1,000, or 10,000 people, even for a smaller company, if the fines are several thousand per individual, right? So that's kind of why compliance is critical. So what does data privacy regulation look like? So unfortunately, this is the part where people get very turned around thanks to our federalism system here in America. We have federal laws and state laws, but some states like ours, Hawaii, don't have laws on data privacy. But because of the way the internet works and you interact with residents from other states, there's that issue. But in general, it's a patchwork of different laws. And a lot of times, older laws on the books that do protect privacy, it was for another purpose. That is, things like HIPAA or FERPA, they existed to protect privacy in a different way. It did not anticipate having the internet and us sharing our information, or, here's my credit card, here's my identity, here's my name, here's, my social security. It didn't anticipate that. Additionally to that, as we are global citizens, if you travel or go or again, conducting business on the internet, we have to be concerned about other laws in other countries and what they mean for us as businesses. So that's kind of what overarching data privacy regulation looks like. So to peel that back, usually when I work with a client or anybody on this topic, I always ask them, you need to first figure out, does the law apply to you? As I've noted, a lot of small businesses will not be under the regulation of the two big laws that we're talking about because they're exempt. That is, you don't meet the dollar amount, the revenue threshold, or you don't collect enough consumer data to be forced into compliance. So that's the main thing is that, where are you advertising and marketing? Is there a state or country law? Who are you collecting data from? Because as I said, this is usually from consumers or residents of a state. It doesn't apply from a business to business situation. This is, again, consumer protection. And then not every piece of information that you collect is protectable, or it doesn't fall as that personal information. So again, you may have a website that collects a lot of information, but none of that information might be protected. And again, it's about personal privacy. And then finally, the last component about making things applicable to you, if you do fall into a threshold, is how are you using the data? You're allowed to collect this data if you notify, and you're allowed to use it for your internal purposes. But a lot of times you'll see that you can't sell this data without the consumer approving it. You cannot utilize it in other ways that you don't have notice for. So again, those are ways to kind of analyze is, does your company even fall under the law? Do you even need to have it apply to your situation? The only thing that I would make mention again about why maybe you should care even though you are exempt, I do think the way that governments, whether they're state governments or other countries, is they recognize how powerful tech companies are, and regulating privacy to protect people's citizens and residents is a way to, bridge that gap of, well, I don't know what's out there. I put my information out there and I'm trusting a company. So a lot of times government regulation does target large players in the market. What happens is when those large players like Google, Facebook comply, we as consumers, when we interact, we begin to expect that level of protection from medium-sized and small-sized businesses because we're used to that, right? When the large players do it one way, we're used to that. It's kind of like sometimes the Starbucks effect of, you go to an indie coffee or a small coffee and you ask for a grande and they're like, we don't have that size. That's a Starbucks. We have our own kind of way we rate, but we're so used to just saying, I'd like a grande, right? And so that kind of bleeds. Same thing goes with privacy in terms of service on the internet. Is a lot of times it shapes our perception and influences the way the market kind of, for small businesses and medium-sized businesses to comply about what larger players do. So just keep that in mind. So we're going to take a look at the regulation. Do you have any questions about that? That's kind of the big picture. That's the forest. That's the overview. Nothing too scary yet. Nothing, I'd say probably a little bit boring, but yes, that's the big scope. Nothing that you've probably, at least, if you read the news or kind of see things, nothing too kind of out there. It's kind of what you see in headlines. Any questions? Nope. Okay. So we're going to take a dive into the regulations and see what's out there currently. So federal law. The US does not have an Online Data Privacy Act. There is not an overarching that says, hey, if you do business on the internet and you collect information on consumers, this is what you must comply with. There is no law. Instead, it is a collection of various privacy laws, as I've hinted at. And some of them are, it is the alphabet soup, definitely in this area: FDCA, HIPAA, that you've all probably heard of, Federal Credit Reporting Act, FERPA, which is for education, the Graham-Leahy Bill Act, Graham-Leahy, and I can't remember the last senator's name, Act, ECPA, COPA, which is the only one that probably you should care about if you interact with children online. But for the most part, many of these laws do not directly deal with online data privacy, and they're more attenuated to a specific industry. Like HIPAA is for medical, FERPA is for education, FCRPA is for financial. So you have to understand that when these laws were written, a lot of times the privacy right is inferred, or it's usually an afterthought is, oh, we're trying to regulate the industry, but we don't really care about the consumers. We should just tack this on in the law. And so the information just happens to be a data set that happens to be on a computer, right? A lot of these companies have online web platforms. If you have a financial advisor like with UBS or Morgan Stanley, you can log on to your finance, right? The data resides on a web platform. So that's how that's backed into is that there's no online data privacy law. It's just that there was a pre-existing law that protects financial data. So who's responsible for enforcing or kind of protecting a lot of these things in terms of violations or online privacy or privacy policies, or just investigating unfair practices? It's the Federal Trade Commission, and they usually have twin goals. So you'll hear a lot of times the Federal Trade Commission considers bringing anti-monopoly lawsuits against or blocking mergers and acquisitions by large corporations because it's anti-competitive, or people creating contracts or agreements to kind of block out competition. But again, that's only for very large players. For privacy situations, a lot of times it involves protecting consumers by them investigating apps and websites where people violate their own privacy or they're basically lying. One of those companies would be Zoom. In the early days of the pandemic, the FTC investigated, your terms of service and what you're saying you're privacy protecting when you're doing a Zoom call doesn't seem to be the case. Zoom has improved and done a much better job after that, but that would be an example of the FTC investigating, issuing fines and penalties against people who companies that do not follow their own contracts and their own privacy policy. So here's the situation. Zoom was deceiving its users, by marketing that your video chats were end-to-end encrypted, that it is encrypted on my end and then on your end. Wasn't the case. And then another example is in 2019, Facebook settled with the FTC for 5 billion, which is the largest, and Facebook would guarantee new privacy protections. And I don't know, I think it's been a mixed bag. They have a privacy committee. I don't know how people feel about how safe Facebook kind of garners, but that was the result of that. Some of the other federal laws, again, you're going to get these slides, but just for, these are the alphabet soup I mentioned earlier. Out of them, again, does anybody here market to or work with, does your website allow interactions with children, or you have an app connected to your website that, you know, download games or things like that? Anybody? No, okay. So just tongue-in-cheek advice, usually when somebody who is an app developer or a website, I always ask, one of my first questions is like, is this an app for kids? Yes, go. I usually tell is like, go to somebody else. Navigating the child online privacy protection rule is just kind of trying to create a contract or privacy policy is just, that just adds so much more work. But just FYI, if you guys decide to expand or create apps or websites geared towards children under 13, it is a lot more work to comply. Another fun one, just the kind of a war story, or kind of not my war story, but just the Video Privacy Protection Act prevented the disclosure of VHS rental records. For those of you that remember that when Supreme Court nominee Richard Bork was put up to be on the Supreme Court, a journalist went to, I believe, the Blockbuster or the video rental store he rented from and just asked to see what the history of what he rented out from them. And that's how we have that. The funny thing is that this law about Video Privacy Protection Act does not apply to Netflix because it's streaming. It only is a very, very specific law to protect your VHS. I don't know who still has a VHS. I think I have like a stack of boxes that we just never got rid of, just like many people in their homes. But I think the last Blockbuster store also closed, what was it, right before the pandemic? But anyway, yes, that's a law protecting VHS rentals. But I highlight these things just to show you Congress moves very slow. We still don't have an online privacy, but only we have these smatterings of what I call kind of interesting things or important things like health and fair credit and family educational rights. But we also have these odd kind of things like the video privacy. It's very narrow slivers bands in industry. That was what I was trying to get across. Okay, so this is our first major one that has generated kind of why we're here. GDPR kind of did that, and we'll get to that. But for the United States, and usually this is often a lot of times for us attorneys, whenever California does something, because it's population-wise largest state and in terms of economic size and power, it has an outsized influence on the rest of the country in terms of that, and that includes legislation. So the California Consumer Privacy Act went into effect in January 2020. In typical California fashion, the voters decided to add and amend it, change it, and also said, you know, it doesn't go, it puts too much burden on small businesses, but it doesn't protect enough rights. So it was kind of a mixed bag. So they then enacted the California Privacy Rights Act that basically amended the CCPA. My typo, it's supposed to go into effect. That is not a typo. They passed it, but it's to go into effect next year in 2023 on January 1st. The only reason that we're discussing it in businesses, especially in California, or do a lot of business with California residents, care about talking about it now is there is a look back period. That is, even though the law goes into effect next year, you're to be compliant about it 6 months prior to. there for certain kind of pieces of regulation. That's why it matters. Anyway, the goals of CCPA and CPRA is basically giving California consumers the right to know what info is being collected. And they have the right to say no to selling or sharing that info. And then there are legal consequences for any company violating those rights. Again, it protects California consumers. But for our state, that one of the largest tourist demographic is from California, a lot of businesses like Hawaiian Airlines, the hotels, things like that, will have to comply with CCPA, even if they're based here, or the physical business is here, but they're marketing and targeting California consumers. And that's kind of how that works. So going back to that rubric that I kind of talked about, does it apply to you? You do not have to physically be in California, as kind of mentioned, for it to apply. The law only applies to for-profit businesses. Therefore, if you're a nonprofit, or there's a lot of times there's a collaboration or association between, almost like a joint venture between a government and a business, such as HTDC and a law firm hosting a webinar, right? Those are situations where the law only applies for for-profit businesses that collect personal info and that do business in California. So we understand we're talking about online, but you can target your marketing, right? Your advertising geared towards California. And then you have to meet any of the following: is that you have gross annual revenues of over 25 million, or buy, receive, or sell personal information of 50,000 or more California residents, households, or devices, or derive 50% or more of your annual revenue from selling California residents' personal information. So I think my understanding for this cohort, for those three criteria, it's an or. None of you fall under that. Is that correct? Yeah. So very easy. If you don't meet any one of those, it's pick one. It's not all three. It's just if it's one of those, then CCPA would apply. But if you're all below those thresholds, CCPA does not apply. So all of this will then just be kind of filler and just kind of FYI. You can win a legal trivia pursuit. So I would let you know, one of the nice things about CPRA is the amendment is it increased the threshold of 50,000 now to 100,000. So definitely most businesses, very small businesses, should still be exempt. So that's the nice thing is that even if you are targeting marketing or advertising to California residences, you guys should still be fine and exempt from the law. But let's just take a look at what the law kind of requires. So, we've been talking about personal information, but what does that mean? It basically means information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular California resident or household. This is beefier language if you're used to HIPAA, which is personal health identifiable information. That is, I can put 2 and 2 together by reading this medical report, and I understand it's you, like I can identify you. But right, this is with any California resident or household. And it's a very expansive identifies, relates, describes. So basically almost anything under the sun that you collect and kind of relates to a California resident or household. Going on the consumer front, right? Remember I said, if you have a business to business type of business that, yes, you do marketing and advertising online, but your services are geared not towards consumers, then definitely this wouldn't apply. But for their definition, a consumer is a natural person who is a California resident, which includes every individual who is in the state. And then for travelers, tourists, yes, if a California resident visits here and they're here temporary or transitory, CCPA still kind of protects them if the way that you had done business, and CPR clarifies it, is that you're targeting or selling that info in California. If you're not doing that, so again, the clarification is a California resident that provides info to a business outside of California, but the business neither conducts commercial activity in California nor sells that info in California shall not apply. So it's a very narrow sliver, but it still can apply if you have commercial activity in California and a California resident comes here. So just understand that the way it's designed is to protect California residents. They don't need to physically just be in this state. It can protect them as they move about. So let's look at some of the information protected. This is, again, far more expansive than what you're used to HIPAA, but let's just pick out a couple. We already know that, your real name, postal address, social security, driver's license. But looking at some of this other information, which a lot of times people who have apps or websites are like, fill in this to create a user account with my website, especially if you're selling products. And a lot of times people for marketing purposes gather personal information. They'll grab at things like for apps, your geolocation. If you're selling health or nutrition kind of service, some biometric data, what is your body mass index, for fitness apps, things like that. It even goes to audio, electronic, visual, thermal, olfactory, or similar information, professional or employment related information, which includes membership in a union. So a lot of times, like I said, the personal information now under CCPA is far more expansive. And if it, again, can identify the user or their household, that would be protected under CCPA. And the final thing that I like about the law, it says it also includes inferences. So therefore, if you can make the logical leap from the information and still guess that that is also protected. So yes, it's almost everything under the sun for California. But again, thankfully for you guys, you don't meet the threshold amount. But it should make you think about when you set up your website, or if you're expanding into an app, what information are you pulling from your users, and how are you aggregating it, and kind of what are you using it for? Because I don't think a Hawaii law would probably, knock on wood, or go to this extreme, but you should be prepared for certain pieces of information to be protected if there is a Hawaii law. So what are these rights? What are these privacy rights that CCPA gives its consumers? They have the right to know about the personal information that a business collects. So a lot of times when you click on a California business that's large enough, and they explain in their privacy policy, we collect the following, that is your right to know. That is your right to know about what pieces of information, because a lot of times we also know, thanks to cookies and other things that people install on their websites for Google, like web analytics, you do not need to voluntarily you don't need to input it on your keyboard. They can pull it by you just visiting their site, right? They can grab your IP address. They can figure out a lot of things about the users and people. TikTok and Instagram track how long or how long you stay and watch a video, or how many times you've watched it. And they're aggregating that, right? Trying to figure out and improve their algorithm to show you more content that you like. So again, it's a right to know what you're collecting on the privacy policy. The other right is the right to delete that information collected by them. Basically, a California consumer can tell a company and say, I want you to delete everything about me on your database or servers. And companies that have to comply with CCPA have to delete all that personal information. They also have the right to opt out the sale. A lot of times these websites will aggregate personal information, especially if there's some type of marketing or research type of situation, and then sell this. For example, Amazon may sell some of its selling information to its own sellers and vendors, right? Because sellers and vendors can become Amazon approved, right? So they can transfer the information of buyers to sellers and vendors, right? So you have the right to opt out of a sale. And a sale doesn't mean just for a sale of money. It can also be an exchange. So people have the right to opt out of that. Finally, the biggest one, the reason why I wanted to spend some time on this is people have the right, California residents have the right to not be discriminated for exercising their rights. If they say, I don't like you looking at my network activity information, or I don't like that you have my body weight and my height in your database because of whatever reason, and the company tries to quiet them or ignore them or discriminate against them, they make it really difficult, the state will protect them. The attorney general will basically go after the company for trying to block or disallow or target somebody for expressing their CCPA rights. So that, I mean, these are kind of rights for everybody if you're a California resident, but this is kind of the first three. The first three are general rights that most of us are used to for privacy policy for large companies. I think it's that fourth one is that, oh, well, you can't make it difficult. You can't discriminate against somebody expressing their right. If not, the attorney general is going to come after you. And on top of that, added to those rights, consumers can exercise these rights. And as a company that has to comply, you have to have at least 2 designated methods for submitting these requests. For large enough companies, it's a toll-free telephone number, which is an added expense on the business. And if the business has a website address. So you need 2. So, right, a lot of times if you're doing your own privacy policy, it's, oh, send us snail mail or send us an email at compliance at whatever your domain name is or your site name, or, just send us an email, right? That's not the case with CCPA. You have to allow for 2 different methods to kind of be served people exercising their right, which again, as I've kind of acknowledged, is an extra business expense for a business that has to offer that. Additionally, you have to have protocols in place to make sure that people who articulate these rights, that it's free. You can't charge them for expressing their rights, even though you have to carry a toll-free number. And you need to be able within 45 days of due follow-up and kind of process these claims. So again, that it's kind of becomes a very Herculean, or it definitely becomes a higher administrative cost in protecting these consumer rights. Again, you guys don't need to comply with it, but this is what compliance looks like for a California company or a company doing business with a sufficient amount of California residences. That's what they have to do. And, it makes people wonder if, am I ready to enter the California market or target it and kind of because it is a large state, there's a lot of wealthy income and a lot of income from that state. But this is one of the things now by collecting online data privacy that you would have to consider if you expanded your business into such a large market. One of the amendments too is, even though that CPRA, right, I said it went from 50,000 to 100,000. They added additional data or information to this long list of what's protected, and they've now have what's called sensitive data, which includes, again, things that that I mentioned, but even your religious and philosophical beliefs, as I mentioned, union memberships, also the contents of your mail and your email, and text messages, and again, genetic and biometric data. In addition to those rights I just showed you, you have the right to also, for California consumers, is right to fix incorrect things in the database. You have the right to opt out of sharing for cross-context behavior advertising. You have the right to limit the use and disclosure of this sensitive data. And you have the right to opt out of the use of automated decision-making. So I don't know about you guys, but the whole point of a lot of websites and a lot of apps is to automate decisions and, you know, kind of run through a flow, or like, right, check here, and then you get, the website spits back out an answer kind of what you need from it, depending on what type of website you have. But you have the right to opt out of that. So again, I think the CPRA puts a lot of hurdles for those companies that needs to comply. But thankfully, they increase the threshold amount for small, what is defined as a small business that is exempt. I'm not going to go into too depth of this because most of this does not apply, but I think it's a good kind of protocol or step for you guys to think about when you're trying to enact or update your own privacy notices and policies. I would have you consider of what you need to notify them, what you're collecting on them, and then describing what rights. Now, this is a good part for being exempt from the CCPA. You guys get to control the kind of the description of the rights. Maybe you do have the right to opt out, but you have to get a description from them, or you set it only that you'll only take snail mail to articulate. As business owners, you get to control the process more so than if you had to comply with the CCPA. As you're updating or adding or rolling out features of your website or trying to collect more information from users or data, consider how you update your data inventories. If you're working with your IT department, is this searchable and scalable? That's always a good question to ask as somebody who is helping you kind of juice more, get more out of your apps or websites. Is how are we tracking this data, or how do we, you know, is this done in the aggregate, or can we individually pull out one consumer's information? Because maybe you do want to give the right to a consumer to delete their information, and it makes it much easier, right? Depending on what tools you're using. Obviously, we're skipping the CCPA. The other big component to this is reviewing your third-party relationships. Who do you use as your IT if you don't have an in-house IT? You know, are they readily available to deal with breaches, hacks, or if you have a customer that says, hey, I want to delete this, and you have no idea where to find it, are they available to you, and can they help you do that, or is that not part of your services? So I would say, you know, review your third-party relationships, or who is helping you with your data and your website and online privacy, because I would say a lot of small-time independent contract web designers or website support, they may not be certified, or they may not be able to comply with privacy laws. And again, maybe you don't have to comply with CCPA, but it is good food for thought to wonder, you know, what kind of vendor or contractor am I using for my own website or my app? Finally, you do need to train employees, whether if you're using them as a customer service type of situation, and to be sensitive or cognizant that, you know, again, this goes back to what I was saying earlier, even if CCPA does not apply to you, there might be, pardon the use of the term, there might be a Karen on your customer service line that demands privacy protections, even though you know, right? And again, having an employee that understands what the privacy laws say, or privacy notice, or what your privacy notice says, is helping, aiding in dealing with those disagreeable customers or consumers making demands of you. So that's why it's kind of important to train your employees and that they understand the process, especially if they're responsible for dealing with angry customers. I'm going to skip that. These are all very heavily detailed for CCPA. It's there if you want to read about how to update your data inventories, how to implement those processes. Again, good kind of roadmap, even if you don't have to comply with CCPA. Highlighting the violations of CCPA, just so you know, it is 2,500 per unintentional violation, and if it's found to be intentional, it's 7,500 per, right? It only takes 100 California consumers to make that a very expensive situation, right? So that's kind of why we're talking about this, is that the fines and penalties is on a per violation. It's a per individual person that is affected or impacted. Okay, so I know that was very meaty and that's very big. GDPR will be less so because if you do not, I'll put it this way, GDPR only deals even with larger companies and dealing with Europe. So if CCPA does not apply to you, then GDPR definitely won't. So we'll probably go through this. But on that note, do you guys have food for thought questions or questions about CCPA or CPRA at this time? Because that is the chunkiest and the meatiest of the online data privacies for US businesses to be concerned about. That is the highest point of the legislation that may impact you in the future. But yeah, everything else is going to be a little less stringent. Any questions?
Joelle would like to know, what if you have EU customers?
If you have EU customers, we will get through that right now for the GDPR, but that's a perfect question and we will cover that in a slide or two. So with that, European Union law, this law went into effect in May 2018. That's why I said, you know, in that summer, flood of emails, spam, what looks like spam to us is, hey, we're updating our privacy policy. It is because of that. This law basically gives EU citizens the right to control their data, how it's collected, used, and protected online through regulators. Organizations, and I use organizations, right? I use businesses for CCPA. That's one of the biggest differences is organizations. So governments, nonprofits, and for-profit businesses must follow GDPR if it applies to them. It isn't just for-profit businesses. And it basically sets strict new rules about how using and securing personal data and about a lot of their language in the GDPR also basically requires strict protocols or using encrypted or secured kind of transmissions. And, you know, for a small company that's struggling or it was like to encrypt and secure everything that they collect from people, that will add extra costs, or doing expensive verified audits with certificate. Basically, it's the equivalent of having a CPA or an accounting firm, you know, run an audit. Now it's just a cybersecurity audit on your company and you have to pay for it to comply. But anyway, that is kind of what GDPR is doing. So just as an example, non-compliance with theirs is it's 4% of your global annual revenue or 20 million euros, whichever is higher. So just come, I did it in order. Amazon was hit with 888 million euros for basically having its advertising practices in question, and that it wasn't by consent, is that it was using consumer data for targeted ads, even though they said they weren't. Google's, I believe, for their 50 million euro fine it wasn't a data breach, but a regulator, and this is how powerful GDPR regulators are, that Google failed to make their consumer data processing statement easy for users. It's not easy for business or tech people. It is easy for the the average user of your data processing statement. It has to be easily understood. And that's what they hit them a 50 million euro fine for. So those are kind of examples of how powerful and how widespread the GDPR and regulators are. So Joelle, your question right here, does it apply to you? Going on that kind of early rubric, is there an offering good or service to the EU citizens? Regulators do look at evidence that an organization sets out to offer goods and services to people in the EU. If your company is not in the EU, but you cater to EU customers, then the GDPR compliance may apply to you. And the second kind of component of that is, are you monitoring their behavior? Are you using website tools that allows you to track cookies or IP addresses or people who visit your website from EU countries? I'll put it this way. The example I like to use is that if a German resident or German citizen wants to order their Hawaii friend that they met visiting here, I think back in the 90s, Germany was the third largest visitor to the islands after Japan, California, and then it was Germany in terms of, anyway, maybe that's why they so love Hawaiian pizza out there. But anyway, if a German resident orders Hawaiian pizza by visiting, I don't know, one of the pizza places here in Hawaii for their friend is, hey, I ordered you a pizza. I logged online and yes, you do offer goods or services, but it's not towards the German resident or citizen. They decided to go to your website. None of your advertising or marketing is for that. You're a pizza place here, right? So it has to be an offering of goods and services directed towards EU citizens. If you're not doing that, and you're not selling data or information or purposefully collecting it from EU citizens to then turn around and sell to other EU companies or kind of establish a presence in EU countries, then GDPR is not going to apply. So again, there may be exceptions, but generally a small US-based company, and by the way, the exceptions are generally data. Obviously, if you're here in Hawaii and you're a data gathering company, that is your sole existence is to gather data on consumer behavior and then sell it to other people, including EU, then GDPR may comply. But if you're a retailer or a food establishment or marketings or kind of hospitality, restaurant, retail, yeah, unless there is a targeted kind of marketing and advertising towards EU countries and citizens, then you will not fall under GDPR. Does that make sense? Is that good?
Janelle would like to know first how you define cater, and also what if your website is in French? Très bien.
That is a good question. If it is in French and it look right, there's Canadian citizens that speak French, right? So, and there are other places there's a number of other enclaves of French-speaking areas around the globe. Catering and directed means that you're paying for SEO advertising or targeting, or you're doing ad buys or things like that towards EU citizens. Merely just having your website in Italian or French. If you're an Italian restaurant and you have your menu in Italian, that kind of makes sense. That's completely different than saying, hey, Italian citizens, our website is in Italian, so you can order things and book your Hawaii vacation with us. And you can travel here and you will have an Italian speaking, right? That is kind of targeted and marketed. Just merely having it in a language is not enough. Marketing towards means is that it's a concentrated, strategic, or directed effort to pick up EU citizens as your target consumer demographic. Does that make sense? I don't want to spend too much time on this, but similar rights as the CCPA, but the GDPR gives 8 user rights. The one that I want to highlight beyond the right of erasure is this. The Europeans, when they created this law, viewed data privacy much different than Americans. They view it as something much more akin to HIPAA here, is that your online data presence or your identity, what makes you you in terms of this data, is yours. They almost have what I consider it's like almost like a suitcase approach. Is I can pack up all my data and I can put it in my suitcase and walk off with it. That's kind of how they view it. And the reason why I'm highlighting number 6 is right to data portability. EU citizens can ask you to remove their information, and this is the kicker, and transfer it to another service. Anybody who works in tech understands there is a variety of website languages, there's different coding and programming because we have Apple for iPhones and then everybody else on an Android based. I don't know if anybody, no, BlackBerry discontinued service, so nobody should be using a BlackBerry. But anyway, right, if you analyze that right, the data of portability is they're asking you to remove your data on a company's website and then take that over and port that over to possibly a competitor or a competing service. And you don't even know whether or not the information in the data encoded, translates, right? So that I wanted to just highlight the extreme of the GDPR. It's one thing for the right of erasure that is, hey, can you delete me off your database? It's another thing about being able to pick up that data and move it over to a competing service. Again, you'll be getting these slides, but I give you, should you want to see what you need to do to comply for GDPR, GDPR actually has a checklist for US companies about how to kind of comply with GDPR. So they try and make it easy for the companies that do business and target EU citizens. I mean, as easy as possible for something like this. Are there any questions about that? Nope. Okay. So, yay, let's turn to Hawaii now. You're going to enjoy this. Really easy, very simple. There is no online data privacy law. While we do protect privacy, the right to privacy in the state constitution, that privacy is more about like identity theft, health data, financial information, employment data. When it comes to online data privacy like CCPA or GDPR, there is no privacy law like that. We do not have an analog. At best, it is protection of data of minors, but that's from the child aspect, sending spam, and yeah, requiring companies to post their privacy policy, but it doesn't really dictate what goes into them. I'm sorry, backing up. There isn't, just to be clear, those things that there's no on any of that. Hawaii does not have that. We do, however, have two laws on data that do exist, and it's just data disposal and security breach reporting. But again, that would apply if you don't even have an online. Back in the day, when you had manual kind of like data entry and input, if somebody went to Queen's Medical Health System and downloaded all their records and walked off with it, that would be a data breach. Or if you had an old laptop that had people's consumer credit card information, right? If you left that laptop or you didn't dispose of it properly and somebody stole that laptop, that would be improper data disposal. That didn't have to be online. So yeah, we have data privacy or data laws, but we don't have anything online privacy. So what that means for you business owners, do whatever I'm just, within reason, because again, online privacy in your terms of service about how to use your website is still a contract. And not to mention misrepresentation, breach of contract, and fraud are still basic common law and regular, that is enshrined in every state's kind of laws or is at common law. So writing whatever you want on your terms of service or your privacy notice and you completely going the opposite direction would be fraud and deceit, any attorney general or whatnot. But all I'm just saying for online data privacy is you have the flexibility to draft your privacy policy and your terms of service the way you want, within reason. So about these two laws is any business or government agency that conducts business in Hawaii or maintains or otherwise possesses personal information, you have to take reasonable measures. So you just have to be reasonable in your data disposal. For the security breach, it's any business that owns or licensed personal information of Hawaii residences or conducts business. You have to notify people of a breach in your security without unreasonable delay. So these laws are very favorable. It's like, just take reasonable measures to dispose of your data. And if there's ever a breach, do it as soon as possible, but it just has to be without unreasonable delay to let people know that there's a breach. Simple. Why are we still talking about this? Again, as a reiteration, Colorado, Virginia, and now Utah as of March 24th, 2022, all have CCPA-like laws. I will let you know though, for all three of them, their law is less stringent than CCPA. They are less restrictive. So even if you're doing business with residents and consumers in that state, if you don't fall under CCPA, you're definitely not going to fall under theirs. But again, they're trying to give their customer, they're trying to thread a loop between business interests, but also protecting their residents for online privacy, of establishing these baseline rights. And many of them you're already kind of used to, like delete. Please do not share or sell my information to other third parties, things like that. As we reopen back up to the world and the world reopens back to us, I would just let you know is that other countries do have their own privacy law. So this is perfect for Joelle's question about French. A lot of Hawaii websites though are in Japanese, Korean, or even Chinese. So you would need to see how their citizens of data, and if you are targeting and marketing, because they also have their own privacy and protection kind of, and you are gathering information on their residences. I'll let you guys review that because that's just on compliance.
I have a question.
Yeah.
So since Hawaii doesn't really have any laws, if I'm trying to capture personal information from my website and I want to use that data for Facebook marketing, to capture people who are similar to them, is that okay as long as I put that into the privacy notice on my website?
Yeah. So a lot of times people's privacy policy says, hey, if by using and visiting our site, we collect this information, it might be race, demographic, location, things like that, because then that allows you to, you may not care about each individual user, but it creates an aggregate picture of what the typical user, and then allows you then to take that and then tailor a Facebook ad of, hey, I'm getting a lot of women in the 35 to 55 range or whatnot. So I can, use the sliders on Facebook. Oh, they spend about $20 on my website every time if you have a retail site, right? And then you can kind of like, okay, or Facebook allows zip code. I know a lot of people from Mililani are visiting my site because I can see it in the, yeah. So long as you disclose, we are gathering that information. That's what everybody else does. But I'm just letting you know, Hawaii has no law that tells you which way or whatnot, what you can and cannot do, because we don't deal with online data privacy. I would still say you need to check with regular privacy laws, like if you're collecting health information, right? Because we have a protection of health information, and we also protect credit card information, but that's a different law. But as to online data privacy, about how you do your privacy policy, yeah, usually the standard practice is just to disclose what you are collecting and what you're using it for. And it's a very simple, we're collecting location, we're collecting this, and we then take this and use this and create a marketing campaign based on this.
Okay, thank you.
Do we have time for like a 2-minute break?
Sure.
When are we scheduled? 12:30?
12:30. Yeah.
Okay. Yeah. Let me refresh my throat, but we're gonna get to the third and fourth part. But let me know if you have questions, because these back end parts are a little bit more for dialogue part if you want to. But exactly like Shanae or yeah, Shanae's question exactly.
Shayna,
like that.
yeah.
Shane, I'm sorry,
That's okay.
Shayna. I will be right back. Gonna just get some more water and then
3 minutes, everybody.
Perfect.
Okay, 3 minutes for real. Ah, you guys came back in 3 minutes.
Thank you, everybody.
Good
I
job.
I promise we will get out for lunch. And again, I'm happy to stay if you have questions. But let's get to it. Thinking about your policy. So this part is really about, and that was a great lead-in question about, what goes into your policy. The first thing that I'd like to highlight is, I use like user terms or terms of service or terms of use. And I highlight those phrases or those words against privacy policy, acceptable use policy, copyright policy, IP policy. You, as business owners, I strive to have clients and business owners understand there is a difference between contracts and policies. Even though when it comes to regulators, it might not feel the same when they're regulating you. It does make a difference between what is a contract versus a policy. A lot of times I see businesses and websites that try and fuse their policy with terms of service. And really, what you need to understand at the base of it, a contract is not a written agreement. A contract at law is basically a mutual set of obligations, a trade for a trade, this for that, that's enforceable by law. That's why you can have oral contracts in certain situations, or you can have implied contracts. When you go to Starbucks and you give them $4 for coffee and they give you coffee, there is a contract there. It's $4 for a cup of coffee. You don't need to write anything down. You don't need to say anything sometime. Well, grande macchiato, right? You have to tell them, but yes, it is implied what the sequence of events is. Why is this important in terms of distinguishing what is and isn't a contract versus the policies that you set about dictating about your website or your app? Well, a policy is more of a course of conduct, and they're basically designed to govern the way the business operates or how it chooses to do things or respond to inquiries, questions, or, delete my privacy. It's a course of action, whereas a contract's more of an explicit promise. And so the difference is enforceability, but also when you can change one. If you've ever been a regular employee, the employer can change their handbook policy by just updating and changing it. They don't need your buy-in. They're like, well, we're changing the way your vacation leave policy. You have to give us 30 days notice now instead of you can go whenever you want or whatnot, or you have to use your rate. Versus if you have an employment agreement, to change the employment agreement, you have to get a sign off by both parties to amend the agreement. That is why when websites and apps or digital programs such as like Microsoft Office or streaming content, right, when they update their terms of service, they usually have that little box, do you agree? And by doing that, you are agreeing to an amendment or replacing the prior contract or agreement. Yes, a lot of times these websites control your access by saying, well, if you don't agree, then you can't access our website. But that was already baked in the prior agreement anyway. But the reason why they're doing it is you are consenting and you are acknowledging and accepting a change to the contract. So where does this leave you guys? You need to kind of peel apart things about how you respond to things like, hey, what privacy information do you have or collected to me if somebody writes into you, versus we agree to only provide access to the website in this manner, or you agree to pay us for our retail products and services, et cetera, right? That is kind of the breakdown of between a contract versus a policy. Does that make sense? This is a very like what I call kind of that abstract notion that business owners a lot of frequently struggle with, what is a policy versus what is a contract. But it is something I like to highlight. Any questions?
I wasn't clear what was the difference between the privacy policy and the terms of use?
So a terms of use is a contract. It would be an enforceable agreement. Is the terms of use tells the user how to use. By agreeing to these terms of use to use our website, this is a contract. This is an agreement that you make with us. Versus a privacy policy is letting people know is that these are our policies with regard to your personal information we collect about you or what we do with it. And if you have questions about it, this is what we're going to do about it, but it is not an explicit promise. A lot of times you'll see privacy policies that we will investigate or take a look or let you know what we decide, but the decision is ultimately in your hands. Whereas in a terms of use, the user must do this and the company that's offering it must do this. That is the difference between a contract and a policy.
Do we need to have both on our website?
It is recommended that if you have a website that interacts with its users or visitors, that is, it is collecting privacy information, and that they are buying, selling, commenting, they have to set up a user account or log into your website, it is recommended you have both.
If you have nothing except a contact form and they put in their email address and name, is that applicable?
That technically is personal information and you are collecting it, right? They are leaving information about themselves with you. Now, again, going back to it, for Hawaii's laws, it's rather lax, right? Or non-existent. So this is why I said this is your decision. But if you don't have them, are you also shooting yourself in the foot when people expect to see them? That's been my whole kind of discussion, right? About how when we use larger websites or things like that, we begin to kind of expect other people to do the same. Any other questions? Great segue, lead-in question. So, yep, for a website and apps, terms and conditions, and then link to definitely your privacy policy. And other policies generally tend to track, depending on what you do, is what we call acceptable use. If you have a community type of website, no harassment, no. If you look at Yelps or Facebook's, is like no derogatory comments, don't post demeaning things, no nudity, blah, 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 all that acceptable use. How do you behave on my app or how do you behave on my website? If people can share user-generated content, then definitely copyright. A lot of times companies would like to protect themselves when people post things of pictures, songs, musics, because they don't want to get in trouble with copyright of somebody else's, right? Somebody else is uploading. So those are other kind of things to consider of putting as policies, not just the privacy. Again, the FTC and various attorney generals have held companies liable for breaching their own contracts and policies. That is, if you're going to put it up there, you have to follow it. If you're going to break your own contract or you're going to break your own policy, then it's better to be a little bit more broad or kind of give yourself more wiggle room rather than just copying and pasting something that you're not going to live by. For online or data privacy, I always say KISS, which is obviously keep it simple, stupid. I think the whole intent and purpose is to let consumers or users know, what are you doing? And so a lot of times people will have sections and kind of, yes, they'll write it in the technical and legalese type, but they also will just give an explanatory statement of, yes, we do collect your personal information and this is what we use it for. But specifically, these are the types of information we collect, and they go into the technical part. What is your company's philosophy about protecting people's data? Some people don't really, I'll be honest, there's some business owners who don't really care about it. And there's others who's like, oh no, I have kids. I'm a consumer and stuff like that. So I want to respect people the way I want to be respected online, right? So, what is your company's philosophy? Then we've gone over looking at laws. I would then have you ask yourself, what data are you collecting? How are you using it? And when somebody asks, can you delete it? What are you collecting on me? How do you respond to that? And then where is this data being stored? A lot of times people use third-party cloud services. You use whatever website hosting. You don't necessarily have it directly on your computer. You access it through another site, right? And then if you have employees, because we know here in Hawaii, everyone loves to gossip and talk about others. Like, oh, did you see so? Right. So it's like you have to train your employees to understand that, this information, even though you view it as just the customer or it's a part of a larger marketing, customer service or whatnot experience, some of this data is private and we have a privacy policy. So therefore you have to respect that. Right. So that's another thing. And then who's responsible for protecting or implementing these data privacies? Is it somebody in your company? Is it you, the business owner? The buck stops with you? Or have you hired an IT services outside the company to help you manage this? Beyond the terms and conditions there's cookie policy and cookie consent statement, third-party agreements, and I already went over employee handbooks and insurance policies. Do you have cybersecurity or do you have online coverage? Do you protect yourself that way too if there's a data breach or if there's a problem? The cookies policy thing is that it's that little pop-up that says, do you accept our cookies policy and stuff like that. You'll see that for a lot of GDPR compliant or companies that need to comply with GDPR. That is why they're doing that and they have that pop up. You don't necessarily need it again if you're a small website and you don't have to comply with GDPR. But again, for a lot of the companies that do use cookies extensively and they have that little pop-up window before you start using the website, it is because of that. I've given you examples. I don't think any of you would have to follow cookies policy. And a lot of times what happens for smaller companies, you roll the cookies policy. So the reason why it's separate for GDPR companies is that little pop-up. GDPR specifically says that you have to have the cookie policy separate from the privacy policy, and it has to have, that's why it's a pop-up, and that's why companies have to do it. For most companies that don't have to comply, they roll and say, yes, we use cookies. And that's usually kind of very, very simple kind of, yes, this website. Usually it's the standard language of what is a cookie, because people think of, oh, it's snack time, not the electronic bit of data that kind of interfaces with your website and preferences. But what are cookies, how you use cookies, all of that kind of gets rolled into the cookie policy. Cookie. Okay, so all that was for, I gave you a copy of cookies, and you can also take a look. I think First Hawaiian Bank, or maybe it's Bank of Hawaii, one of them has a pop-up, like, and you can see what that looks like. But again, your cookie policy and cookie consent notice isn't have to be GDPR compliant if you're not under it. Do you have any questions about the policy kind of part in the drafting? Again, I think for many of you that implement privacy policies, being in Hawaii and not having to follow CCPA or GDPR, you will have relatively simple privacy policies. And a lot of times it's probably, we respect privacy and this is what we collect from you. And this is how, if you wish us to respect your privacy, this is how you email us or mail us or, express your rights.
Hey, Ryan, I just want to chime in. You've got 3 minutes left.
Okay.
And unfortunately, we do have to stop right at 12:30.
Okay.
Sorry.
So I'm going to jump down to the most important part of the third party situation. If you're thinking of rolling out much more expansive parts of website or apps or hauling in a lot of privacy data, you probably would like to speak to your insurance agent and consider cyber insurance. Because it covers network security breaches, it covers privacy breaches or hacks, business interruption, your website goes down or whatnot, media liability, so that copyright and trademark infringement, and then errors and omissions if you have some type of consulting or reliant on information about what you should and shouldn't have done with information on your website. It might be expensive, but it might be something worthwhile as another way to not only shore up your compliance and protection, but like I said, you would rather have insurance than not in a situation where you are in breach, or you find yourself of running afoul with others. The only other thing that I would say about third parties is, again, really review your contracts with outside vendors, suppliers, website people. That would need to, a lot of times they waive their risk, or they limit your liability to what you pay them, or they have no liability at all. And as you relying on their expertise to do your websites or do your data management, kind of leaves you stuck with the ball, right? Or like if you have a complaining customer and all you can say is like, oh, well, we're not responsible, and their reaction of who is, and you cycle that back up, they're going to say, look at your contract, we're not responsible, you have to deal with your customer. So I would leave you on that note. And with that, I can do one question.
And I was just going to say very quickly, if you could also send me a PDF of the presentation, so anything that we weren't able to cover by 12:30, they'll be able to see in the presentation.
Yeah. Yes, I will. And that there is that packet of
Yeah.
samples and stuff.
Somebody's got
Any
30
question?
seconds to ask a question.
Any quick question? Nope. Okay, cool. None of you fell asleep that I could see. Great. Thank you. Have a great afternoon.
Mahalo, Ryan.
Don't sweat this too much. Again, you guys we're in the easy privacy state. So just think about it and kind of consider putting them up if you don't have it. Okay.
Bye, everybody. Thank you for this
Okay.
wonderful cohort. I'll see you all in the one-on-ones.
Thank you.
Bye.
Bye.